I do want to also make sure that I understand this. I'm told that in a past life you actually worked for Chevron. Is that correct?
I worked for Chevron and actually grew up in Fort Worth, Texas, not exactly in your district.
And yet you still got appointed to your position. Congratulations.
I was actually appointed to my position because of my specific industry background. So
that's good. That's very good. Well, my first question, I'll ask you, Mr. Smith. Does the law stipulate which entity has to be applied to first for an export permit? Do you have to get approved at DOE to export LNG, or could you go directly to FERC and ask to have the facility approved before DOE has approved that it could be exported, or does it matter?
Yeah, the law actually gives us some flexibility, and it gives applicants some flexibility. So the way that we've handled that question is we have to come up with some order in which we're going to consider applicants. So applicants are free to apply to FERC. They're free to apply to the Department of Energy. But we've given priority to those applicants who have already started that FERC pre-filing process, which is the process which you're starting to spend real money. And we're also considering those applicants on a first-come, first-served basis with priority given to those who have started their FERC pre-filing process.
The law doesn't stipulate it, and the practice is that an entity can apply either place, but the DOE gives preference to those applicants that have already started the facility permitting process at FERC. Is that correct?
We are considering first those applicants who have started their FERC pre-filing process.
Okay. And is this go either place first policy going to be maintained, or is there a possibility that you might clarify it and set some specific criteria as to what you have to do first?
Well, the department looked at a lot of factors when we were considering the order in which we're going to rule on applications. There's a lot of ways that we could have done that. We could have looked at business models. We could have done other evaluations. But the standard that we had was we wanted something that was open, that was transparent, that was simple, that was fair, and that helped us push the project that might be more viable to the front of the queue. So we wanted a very subjective standard that didn't have some, a very objective standard that didn't have some subjectivity where we had to evaluate business models. So that's the order that we're moving forward on. There's a PDF on the Fossil Energy website that lists those applications in order, and that's the process that we're using going forward.
Okay. And Mr. Wright, does FERC have a timetable for its review of its process? Do you try to get the permit to build and construct done in so many months, so many years? Do you have a guideline for that?
Well, we do, and we're in relatively new territory with export applications for construction. The import applications, the regasification facilities, were much simpler, and given that we would get all the information we would need, including the pre-filing period, we would authorize LNG import facilities somewhere between 18 to 24 months. With export facilities, the engineering is much more critical. It's much more safety conscious, environmental conscious because of the use of refrigerants and natural gas liquids. What we're seeing is we are very dependent upon the applicant being able to finish its engineering studies to supply us with the information for our evaluation.
My time has expired, but could you give us you try to get your review done by X months, is there an X that you use, or is that not possible?
We would love to get our formal application review done in 18 to 24 months.
18 to 24 months. Thank you, Mr. Chairman.